Would you please divulge some juicy details that you can about the, if you're able to, between the Samsung Apple feud and courtroom battle, and talk a little bit about the design patents
Right.
that were
Right.
challenged in the courtroom?
Right. There's for those of you who are not completely familiar with the different types of patents. There's actually different types of patents. There's the utility patent, which is used to protect novel and non-obvious chemical compounds, methods, manufacturing techniques, articles of manufacture. There's a second type of patent called a design patent. So what you're protecting with a design patent is actually the way something looks and feels. You're actually protecting what we call the ornamentation or ornamentality of an article of manufacture. In the Samsung Apple case, two of the five patents that were in suit, I believe there were five patents in suit, two of the patents in suit were actually design patents. So they weren't covering a novel device like an integrated circuit. They weren't covering a method or a procedure or a chemical compound. They were actually protecting the way something appeared. And one of the patents did, in fact, cover the rectangular but curved, cornered look of the iPhone, which has sort of a kind of a boxy look to it, but with the curved corners. And I believe there was a second one that involved the curvature of the back of the phone. And you might say to yourself, how can somebody patent a curve? Who invented that? But what you're really doing is you're protecting that curve on the article of manufacture. So they're not getting a patent on a curve. They're getting, the entire look of the cell phone in this particular case, which includes the rectangular shape, which includes the thickness and the radius of the curves relative to the straight lines and the way it appears. And that's what you're really protecting. And sometimes design patents are just as valuable as utility patents. Now, clearly, there were three, I believe, utility patents also in suit. And I will admit that in a former lifetime, I actually wrote patent applications for Apple at my prior law firm. And I don't know if Apple products still do this, but I wrote a patent application on what they called the genie effect. So when you closed a window, it looked like a genie sweeping down and being sucked into a file at the bottom of your screen. Well, I wrote that application.
Yeah.
And you think to yourself, how is that possibly novel or non-obvious? Why should anybody get a patent on that? But in this particular case, how many of you really love the ability to take your forefinger and your thumb and expand something on your tablet or your cell phone? I don't know who wrote that patent or who filed it, who prosecuted it, who thought it was going to be relatively important when they came up with the idea. But I see almost every tablet, almost every smartphone, I see the newscasters on CNN doing it when they do this. Well, somebody had a really good idea, and they're entitled to protect it.